Yes.
Okay, we're ready.
Inspirational. Adequate notice of this special meeting of the Lawrence Township Council being held on Thursday, June 26, 2025, was forwarded to the Trentonian, the Times, and the Princeton Packet on June 23, 2025, by the municipal clerk. We will now have an inspiration and a pledge of allegiance.
And we carry out our work at this meeting in a just, honorable, and sincere manner, always bearing in mind our duties in continuing to keep Lawrence a wonderful community in which to live. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, if we could have the roll call, please.
Mr. Bobbitt.
Here.
Mr. Kaneki.
Here.
Ms. Perry. Here. Ms. Santos cannot be with us this evening. Mayor Farmer.
Here. Thank you. And thank you to council for being here this afternoon. Resolutions. The first resolution that we're looking at is the authorizing the resolution of council endorsing the housing element and fair share plan adopted by the Lawrence Township Planning Board.
Mayor,
You noted, mhm.
may I just put something on the record?
Yes,
And Art, jump in if I'm missing something. Our affordable housing plan, all municipalities in the state of New Jersey need to file, and there's a deadline of June 30th, 2025. We had a public hearing before the planning board with regard to this housing plan, and it was on June 16th? No,
Earlier.
Earlier. The public hearing was the sixth,
Six,
the public hearing was on the 16th.
Yeah, June 16th.
Okay.
Okay, at that time, there was a presentation that was presented, there was, the public had a chance to participate, and eventually the planning board did vote unanimously to pass the resolution. In my conversations with Mr. Sypek, we believed it was appropriate for the governing body to pass a resolution so we can meet the deadline of June 30th. And that's the purpose of this special meeting, in order for us to provide enough time for us to file the plan before the deadline, and we needed to gather in an emergency. It's kind of, we have one meeting a month now, and it just didn't line up. So that's why we're having this meeting at this point in time. And then, lucky enough for all of you council members, Beth our planner was available to come, and we thought it was appropriate for her to just provide the presentation that was given to the planning board for the council members that are not board members, before you are asked to vote on this. And so that's just, I wanted to set the table so everyone understood, in the public and for all of you, that this special meeting came about out of necessity to meet a deadline of June 30th.
And I'll just add, and everything that the manager said is correct, but, we're in litigation in this. We have a Superior Court, New Jersey action involving our plan, and part of the court order of Judge Lugie, the assignment judge, we already filed the plan with the court, and then we filed the planning board resolution. There was some issue whether or not we had time to go into our July meeting. I think after much discussion, including discussion with the planning board attorney, we felt it best for us to file everything by the June 30th date. So that's why, I was somewhat insistent that we do this. I know and I thank council members for coming here, because I know it's an inconvenience, but in terms of the overall picture, overall scope of what we're doing, it's a really critical document for the township that you are hopefully endorsing today. And one once that happens, I will file that with the Superior Court Clerk's office, presumably tomorrow after I get a certified copy from the clerk, and that will fulfill our obligation under the court order that we are under. So, thank you.
Thank you both for that clarification. We appreciate it. And so with that, we also have Ms. McManus with us today, and she will be presenting to council a version of the round 4 housing plan, so that all may be educated or share the information. Thank you so much for being here also.
Yeah, my pleasure. My pleasure. I hope you can see the presentation. Okay. So this is going to run through an overview of what's contained in the housing plan that the council is being asked to endorse. There we go. So very quickly, I want to give a little bit of background as to why we do this in New Jersey. And so there are 2 big reasons. First, from a legal perspective, New Jersey municipalities have a constitutional obligation to plan for low and moderate income housing pursuant to a 1975 court decision. And there's a lot more case law and statutes that are applicable to this, but at its core, it started in 1975. Following that, we have, in terms of the legal perspective, we have a huge incentive to go through this process, and that is we want to have protection from builders remedy litigation. It's a type of exclusionary zoning litigation where municipalities, if they're non-compliant, specifically, I think in relation to this meeting, for municipalities that don't adopt and submit and councils that don't endorse housing plans, it means that they are vulnerable to builders remedy litigation, which means that a developer could, through a court process, essentially usurp our planning and zoning abilities, and they would do so in order to construct an inclusionary housing development. So it would be 80% market rate housing, 20% really at the most affordable housing. And that development would not comply with the zoning. It may be in a commercial district, it may be in a single family district, and it would certainly be at a density that's greater than what the municipality is comfortable with. It's just the nature of all builders remedies. They look very different throughout the communities, but it's always essentially bigger than what the town is comfortable with, and that's why they use this Mount Laurel process in order to receive the builder's remedy. They're able to go around the municipal zoning. And it is hugely disruptive to a municipality. And so towns like Lawrence, we do this so that we can maintain control over our own zoning and land use in the community. But in addition to these legal reasons, I mean, the other reason to think about this and engage in the process is to advance affordability and quality of life in communities, and planning for affordable housing, making sure that folks of all income can live in the community or perhaps can stay in the community is helpful for community building and really making a community open and inclusive to everybody. Now, when we talk about affordable housing, what it means at its base is it's a rehabilitation obligation and it's a new construction obligation. I'll go through each of these and how it relates to Lawrence. But before I do that, just a little bit more information. One of the questions I often get about affordable housing is who qualifies. And so what this table does, and this is actually a replication of what's in the housing plan, is it provides an example of who would qualify. And so if we take a look at, for example, the 3-person household, the highest income that can qualify for affordable housing is about a little less than $97,000 a year. And so the incomes for those that qualify, at least at the moderate, at the top end, are really pretty high, I think, to many people's surprise. And so when we talk about affordable housing, it's very low income, which is 30% or less than median income, low income between 30 and 49% of median income, and then moderate income, which is the top, it is 80% or 50 to 80% of median income. And these income figures are, as you can get a sense from the table, it's not based on what exists in Lawrence Township. It's based on a multi-county region. In your case, it's Monmouth, Mercer, and Ocean counties. So as we talk about why we're here this evening, maybe this afternoon, it's really to go through what is the second and final step in, maybe not the final step, but the second step in this process, which is to submit all of our documentation. And the planning board has quite honestly done a lot of the hard work already for you guys, in the sense that they've gone through, worked with me to put together the housing plan, and then adopted the housing plan. They did so on the 16th. They adopted the resolution. We know from Mr. Sypak, it's already been submitted, and so having the council hopefully endorse the resolution this evening will be the sort of the final step in the formal submission of our housing plan that is necessary so that we can enjoy protection from builder's remedy. Because if the planning board, for example, had not adopted it, we were unable to get this process done by the 30th on July 1st, we would be vulnerable to builder's remedy litigations. So the deadlines are very serious and very tight in the Fair Housing Act. So for Lawrence's affordable housing plan, the first component that I want to address is the rehabilitation obligation, and that is 68 units. That is a calculation, first was done by DCA initially and later assigned to the township earlier this year. And it is based upon an estimate of low and moderate income households that live in Lawrence that are also living within substandard units. And it's just an estimate based on census data, American Community Survey data. And the way that the township can satisfy this obligation is actually the same way that the township has been doing so for many years at this point, at least a decade that I'm aware of, but potentially a couple decades. And that is through continuation of our home improvement program. You guys work with an existing affordable housing administrator, Central Jersey. I'm sorry, I forget the full name, but they're
Piazza and Associates?
What's that?
Piazza and Associates, is that what you're talking about?
The Piazza does a lot of your new construction, but you have a different organization that does your rehabilitation program.
Yeah. Affordable housing.
Yes. Central.
Administrators. Affordable housing administrators.
Yes. So they operate your existing program. My recommendation is we just simply continue it. And what this ultimately means is that property owners, whether they're the homeowner or perhaps the landlord, they can apply through this administrator and indicate that they have a major system that needs to be upgraded. So it's not painting a home. It's something that is relevant to code compliance or perhaps weatherization or safety. So think about things like roofing, HVAC, lead paint removal, for example. They would apply to the program, and if the home indeed meets the work that they've identified, if they are indeed low and moderate income households, then they would be eligible for a no interest loan in order to conduct the work. And in exchange for that loan, there are 10 years of affordability controls placed on the unit, which ultimately mean that if the unit is sold, or perhaps if it's a rental unit, the tenant leaves, the next homeowner, the next tenant must also be low and moderate income. So it helps to upgrade homes that are in need of assistance, but also promote affordability in the township. For your the next component of the obligation is referred to as the new construction obligation, and it's often labeled as the rounds obligation. So in this case, this first example is the rounds 1 and 2 obligation. We also have the round 3, and now we're in round 4 obligation. So for your first 1 and 2 rounds, these have been combined in terms of its obligation and also the way it's satisfied. It's 891 units, and I'm not gonna spend a lot of time on this because quite frankly, it's fully satisfied. You guys have constructed all of the affordable units. They're in place. I have just a few examples of what satisfied that component of the obligation. Your round 3 obligation, and this is the obligation that was the subject of the township's entire round 3 plan, your settlement agreement process that you did with Fair Share Housing Center, as well as some other affordable housing developers. The obligation was established through the court process. It's 1,110 units, and the township went through a vacant land adjustment in order to have a downward adjustment of that obligation such that it would reflect the vacant and developable lands. In that process, the vacant land adjustment has also been approved by the court already. So that's 702 already paid, and the unmet need of 408 has been established by the court and approved by the court. So the 702 already paid is your realistic development potential, and that's the portion of the obligation that must be met with projects that are certain. And as you'll see in another slide, we've done that as part of your third round plan. The unmet need of 408 is typically satisfied with more passive programs. So it might be overlay zoning, for example, is one method that's used, as opposed to zoning a site that shall be developed inside of the next round or the 10-year round. So a little bit more on a vacant land adjustment. Like I said, it's this adjustment, and it's really an academic or a theoretical exercise where you're identifying all of the vacant and developable parcels, determining its capacity for inclusionary zoning, and the resulting affordable units that would be located on each property. The sum of all of them results in your RDP, and in this case, it was 702 units. And so just an example, if you had a 1 acre property that was identified as vacant, there would be a density assigned to it, not that it needs to be developed at that, but this is a theoretical or an academic exercise. You would assign a density to it of, let's say, 10 units an acre, so 10 total units. The affordable housing set aside must be 20%, so that's 2 units. The RDP from that property would be 2, and that was done as part of your third round plan throughout the entirety of the township, with the sum of all of those individual RDPs being 702 units. And so that was done for the third round. It was approved. And as I'll talk about in a minute, we had to do an update of that for your fourth round. So for your round 3, this is the table that addresses or provides all of your round 3 projects. Now, a number of these have been constructed. In fact, the vast majority of them have been constructed, but there do remain some that are outstanding or perhaps under construction still. For example, the Brandywine site is the townhouse development behind the Lennox Drive office developments. So that is, I think, nearly done for construction at this point. Nexus Properties off of Spruce Street, that has been approved but not yet constructed. And Quaker Bridge Mall is not yet approved, but the zoning remains in place. So in terms of decision-making from the council, round 3, your RDP, and as I'm going to show you in just a moment, your unmet need is already addressed from the perspective of all of the zoning has already been adopted. So for your round 3 unmet need, there were also a handful of mechanisms that were zoning that was already adopted. It includes, for example, sites along Princess Road, the Lawrence Shopping Center. That's actually an example of a property that has been not only zoning, not only site plan approval, but also under construction with the RPM site on Texas Avenue. And then the Mall Access Road property by Tricone Engineers and FAMPAC. The Tricone Engineers is actually coming to the planning board right now, shortly. And so, as you can see, we're starting to get movement and traction on these unmet needs sites, which is a good thing as we go through the compliance process with the court to be able to demonstrate that our zoning is being utilized by developers and therefore is going to lead to the production of affordable housing. So for our round 4 obligation, and while I wanted to go through the rounds 1, 2, and 3 with folks just to see all of the work that the township has historically put in to meet its obligation, but the round 4 is really the primary or the most important part of the housing plan. It sits, and this is where all of the decision making sits with the planning board as well as with the council. So our round 4 obligation is 320 units. That was assigned to, originally calculated by DCA and assigned to the township by the court earlier this year. Now we have an additional RDP of 56 units, and that is based upon review of development activity that has occurred since your third round RDP was calculated, and as well as review of properties that have made themselves available for affordable housing. One of the aspects of having a vacant land adjustment means that when you have a developer that becomes when you have a property that becomes newly vacant or newly available by virtue of a developer coming forward and saying, I am willing to construct inclusionary development here, it means that the municipality has to consider the site as to whether or not it generates an affordable housing obligation, and oftentimes they do. Not always, the site has to be suitable, it can be a wetland property, for example, but if the site is suitable, it's very likely going to generate an obligation. And that's part of the reason why we have the 56 unit obligation here. So this accounts for a development approval, it accounts for one of the sites that I'm going to talk about in the fourth round, and also accounts for the 3131 project, which 3131 Princeton Pike, the office development off of Executive Park Drive and Princeton Pike that was subject to a redevelopment plan and site plan approval. That property is also going to generate RDP, and just, I will say it's very helpful that it does in terms of just how the numbers work and helping us meet our obligation. So I don't want folks to look at that 3131 site as something that generated a concern that needed to be then solved. It's actually helpful in the way that I was able to put together your affordable housing plan. So for satisfying your RDP, one of the things I want to highlight is that we have a surplus. So Lawrence Township has a really excellent history of providing affordable housing, and your efforts in the past are continuing to be helpful today. So we are satisfying our obligation with the 3131 project, as well as with Carriage Park, which is an existing project that I've identified as surplus credits that we're able to use. And then we have additional surplus as well with additional remaining credits from Carriage Park, additional credits from the 3131 Princeton Pike project, additional credits from the Quaker Bridge Mall site that is subject to zoning that we don't need to satisfy our RDP, and then with the 3641 Lawrenceville Road property. And that is, I'll show a site map on that in just a moment, but that is actually the property that I had referenced as having a developer come forward and as a result now generates RDP. So let's talk about our round 4 sites that are new. I'm not going to, for example, go through the Carriage Park property or the 3131 Princeton Pike property. Instead, I'm going to focus on those sites that will be subject to new zoning through this process. So starting with the 3641 Lawrenceville Road property, this is at the corner, as you can, well, it's probably too small to read, but it's at the corner of Lawrenceville Road, 206, and Province Line Road. Some folks might recognize the property as having been the site that was the application of the Care One proposal. This is about 6.5 acres, and the property owner had approached the township looking for really expansive multifamily housing on the property at significantly higher densities. And so as a result of them coming forward proposing multifamily inclusionary housing, they were proposing affordable housing as well. As a result of that property coming forward, I know that now that it's going to generate an RDP, and so not only have we accounted for it by generating the RDP, but we're also granting it zoning to the property pursuant to the housing plan at 10 units an acre. So admittedly at a much lower density than what the developer has requested, however, a density that is appropriate for the area of the property and the area that the property sits within. Essentially a single family home district, notwithstanding the fact that it is next to the corporate campus of BMS. So the 10 units an acre will facilitate a townhouse development and will provide adequate space to account for the historic district along Lawrenceville Road, as well as for conservation buffer in the rear of the property. The next property that I do want to highlight is our 3131 project. This is new to the housing plan, and not necessarily new to the township, but new to our housing plan. It's about 8.5 acres, and it was issued a site plan approval for 204 units with a 15% set aside of affordable housing. Now for our unmet need, as I had gone through in the third round, we have a handful of sites that are subject to some of them are subject to overlay zoning. RPM is a different story, but the Princess Road sites, for example, are overlay zoning. For our round 4 unmet need, we are obligated to expand our unmet need mechanisms. And then on top of that, the Fair Housing Act has put in place a much stronger requirement to satisfy a portion, minimum of 25% of our unmet need through inclusionary development. And so that's part of the reason why we've put together these sites. And the other reason, in particular with ETS, is we have a property owner that has come to the township. And so with ETS, this is, of course, the corporate campus at Carter Road and Rosedale Road that has been in the township for a very long time, but unfortunately is largely vacant at this point. And so ETS has approached the township to indicate that they're looking for redevelopment opportunities that include inclusionary housing, and more specifically would be a mixed-use development. It would be a mix of retention of a portion of their campus as is, so the area south of the Ring Road or labeled as ETS Drive there, those buildings would be retained. And it would be a mix of uses with those office, as well as that's where their hotel and conference center is located, with residential and commercial mixed use to the north side of ETS Drive. And so that would be a mix of residential inclusionary development as well as some commercial uses as well, with the theme that has been discussed thus far is somewhat of a town center. Now, there's no design but when I'm referring to a town center, it's really a walkable area that has integration between commercial and residential uses, such that it feels like a traditional town center. Also, other things I want to highlight about this is the fact that the site has substantial environmental constraints on the property. You can start to get a sense from the map here with the blue area highlighting the flood hazard area, and there's some wetlands underneath that as well. You can start to see the brighter blue poking out. And so while the site is substantially environmentally constrained, the anticipated development on the property will be concentrated on those areas that have already been disturbed. So for example, the areas of the buildings on the north side of ETS Drive, the area of the parking lots and lawn areas, as opposed to clear cutting the woods, particularly those to the south of ETS Drive. The development will be located to the north of ETS Drive and will be able to utilize these existing developed areas. And the total number of homes on the property will be permitted will be 800 homes, of which not less than 15% shall be reserved for senior housing, like active adult housing essentially. And there'll be a 20% set aside associated with that. So 20% of the senior homes, 20% of the family homes on the property. And so this will ultimately create a redevelopment opportunity for this largely former corporate campus. We'll also create new housing opportunities for folks, and we'll be able to do so with concentration of that development on the existing developed areas, and while preserving substantial amount of open space, including, I should note, there's the Lawrence Hopewell Trail runs through it, as well as another trail whose name I forget, but those areas will also be preserved. And then we also, for our third unmet need mechanism, is 3450 Princeton Pike, and this is at the corner of Princeton Pike, Lennox Drive, also Meadow Road, also Louisville Road. This is an existing office development that, again, the property owner came to the township seeking redevelopment opportunity. It's about 10 acres. The housing plan assigns a density of 10 units an acre to the site, along with a 20% set aside on the property. And so I'm anticipating multifamily and or townhouse development on that property. And so all told, while the housing plan is several dozen pages, what we're really talking about are 4 properties that are subject to the plan or newly created in the housing plan: the ETS site, the 3641 property, the 3450 property, and then the 3131 Princeton Pike property. Although admittedly, as I said, that's a new site to the housing plan, but not a new site to the township. And so your housing plan is, it satisfies your fourth round RDP, it satisfies your with substantial surplus credits, and it also satisfies your fourth round unmet need. So the next steps are to, if the council's inclined to endorse the housing plan, we would take that resolution, submit that to the court, and there's some additional follow-up work that I'll be working on in the next month. And it will include some administrative documents like an updated affordable housing ordinance. I'll work on a spending plan that will come before the council. And we'll also put together some draft ordinances for consideration. Draft ordinances for those sites that I just discussed. I would anticipate that the ETS site will be a more significant planning exercise as opposed to just submitting some draft bulk standards, given the size of it and the impact upon the community, and I think the importance to the community as well. And once all of that documentation is submitted, there's actually a 2-month objection period. And so for the next 2 months, developers, property owners, residents, affordable housing advocates have the opportunities to submit an objection to the Affordable Housing Dispute Resolution Program. That's the program, the arm of the judiciary that will be doing the review of housing plans and issuing approvals for them. And after our objection period, which ends at the end of August, we have an opportunity to go through the mediation process to determine if or how our housing plan needs to be amended. We can do so through the end of the year. And we'll say ordinances don't need to be adopted until March of next year. While we're obligated to submit drafts, we have a lot of time prior to adoption, presumably because they want us to be able to go through the objection and mediation process before going through the step of adopting an ordinance that could potentially need to be amended at the end of the process. And once we get through that, or perhaps if we get no objections, at that point, we're just waiting on the compliance certification, which is essentially the court's stamp of approval that our housing plan meets all of the applicable requirements. And it also means that we have immunity from builder's remedy from then through the end of the fourth round, which is July of 2035. And that is also the longest time period that a municipality can gain immunity for. So with that, I'm happy to answer any questions.
Mayor, can I ask a question? Yes. Beth, thank you very much for coming here today and providing this summary. I wanted to make clear two very important pieces of information. The first is the township did not seek out these four areas and say, these are areas that we want developed. It doesn't work like that. There's a common perception out there that the township goes out and selects sites and then they are built upon. And for the community's purposes, that's not what happened. These sites are privately owned sites where developers and their team of professionals came to Lawrence Township and said, this is the spot that we want to build upon and we want to develop. We have two options, really. One is to say, no, thank you, we don't want any, but there are significant consequences for us to say, we'd rather put our heads in the sand and not deal. And Beth, if you could just explain how we've taken a vacant land adjustment and how that rolls into I think our obligation, our responsibility is to, on behalf of the community, meet with these prospective developers and work out plans that we think are most appropriate for the fabric of our community. But could you just explain it to council?
Absolutely. So there are some advantages and disadvantages of taking a vacant land adjustment, although I don't want to present it like it's necessarily a choice for communities. Most towns take a vacant land adjustment because they don't have another option. And if you look at your third run obligation of more than 1,100 units, you literally did not have the land to fulfill that entire affordable housing obligation. And now if you think about a fourth round obligation of 320, we still don't have enough land for that. So while there's advantages and disadvantages, I want to be clear, there's really not an option for most municipalities, including Lawrence. So when a developer comes to you, and it can be literally any of these properties that are being discussed in the fourth round are new sites, we do have an obligation to meet with them. It's in our best interest to meet with them as well, to understand what they're proposing, to see if we can work with them. However, I want to be really clear that not meeting with the developer or saying that we don't prefer your property does not mean that it does not mean that the obligation ends. In fact, by virtue of that developer or that property owner coming forward and saying that they have a site that they can and will provide affordable housing on, it generates an affordable housing obligation. And so let's say the 3641 property, where the Gould House is located, I should have mentioned that as well. That property did not generate an RDP in the third round because it has an existing structure on it, and that was part of our court approval, and that's perfectly fine. However, as the developer comes forward now during the fourth round, saying that they're willing to build 150 or more housing units on the property, the site then generates an affordable housing obligation for the township. Whether we zone the property or not, the obligation is generated. And so 3641 is a relatively small property, but if you think about something the size of ETS, for example, where they have more than 75 acres that are, they have about more than 150 acres that are developable. We are working with around 75, but they have more than 150 acres that are developable. If the township is unwilling to work with that property owner, what I would foresee is them asserting that their 150 acres should be redeveloped at 10 units an acre in order to help the township meet its affordable housing obligation. Now, would that ultimately be what was awarded by the court? I can't say for certain, but through engaging with the developer, we were able to say, well, it's not going to be rezoned for 100 on 150 acres. Instead, we're going to be working with you on these 75 acres. And I think that's to a huge advantage to the township. And so that's one example of how it can work to the town's benefit, by working with the property owner, by being able to mediate with them in a way that is outside of the court process, outside of the court potentially imposing upon the township. We're able to come to terms on our own. But the bigger point that Mr. Newmansfried is making is that by virtue of taking a vacant land adjustment, it means that we have not just an obligation to work with and meet with the property owner, but we have an affordable housing obligation that gets generated when a property becomes available by virtue of new vacancy, if, for example, if a building burns down, or by virtue of a property owner coming forward. And so that would apply to ETS, 3641 Lawrenceville Road, as well as 3450 Princeton Pike. All three of those properties are sites that developers came to the township with a specific purpose of being included in our housing plan. And just to be clear, I don't want there to be surprises. This is an issue, it's a huge issue right now as we're all trying to prepare our housing plans, but it's the nature of vacant land adjustments throughout the life of your vacant land adjustment, including ultimately for the next 10 years. And so that's why I say it's one of the downsides of taking a vacant land adjustment is that you have to be responsive when developers and property owners approach you. Because you may be generating an obligation. It doesn't mean that you necessarily have to give them what they're asking for. And the 3641 Lawrenceville Road property is a great example of that. I suspect the developer is going to be disappointed when they see the density set forth in the housing plan. So you're not obligated to give them what they want, but you are obligated to meet with them to see if you can come to terms and to recognize that there's an affordable housing obligation that's generated.
Beth, can I ask you a question? For the sake of clarity, can you explain the process of vacant land adjustment? And most importantly, as the manager stated, this is not something that the council or the township or anyone solicited, that they came to us. Please explain the circumstances if we do not meet with them.
Okay, so if we don't meet with the developer in this process, where we're in right now, in terms of the, as we prepare the plan process, what I would anticipate, if we got a letter from a developer and we said, thanks, but no thanks, we don't even need to have a conversation with you. What I would expect is they're gonna file an objection, to our plan between now and August 31st. And they're gonna say a handful of things. That one, their property is suitable for affordable housing in whatever way it may be. Two, that it's available for affordable housing, and therefore it generates an affordable housing obligation. Five, I'm losing count, but next they're gonna say that the density is beyond what the municipality would be comfortable with, and quite frankly, it might be beyond what they want, because a lot of stuff gets negotiated. But they're also gonna say that the municipality couldn't even be bothered to meet with them, and so they're operating in bad faith, and shame on this municipality, and they're gonna use that to the extent possible to try to create leverage for themselves in this process, to make the municipality, make Lawrence look like a bad actor that doesn't want low and moderate income households in their community. And because that's just the typical talking point, and frankly, sometimes it's true in communities. I don't think that's the case here, but there's nothing to prevent folks from taking that scenario and putting it in that light for the court, for the judge to consider. And so for calculating our fourth round affordable housing obligation, I'm obligated to look at what development approvals, what land use changes have occurred. And I did that. There was a development approval back in 2017, late 2017, that occurred right after our RDP was established. And that generated, I think, 2.4 units. So something very small. But some of these other properties, for example, ETS, all of the properties, ETS, the Princeton Pike property, the Lawrenceville Road property. Now, the advantage of working with the developer is that we have an understanding about what they're seeking, so that in the case of ETS and the 3450 site, we're able to come to terms. And I think we have very likely eliminated an objection from those two parties. If there's an objection, it might be just simply to ensure they have an opportunity to work with us, but I wouldn't see it as a substantive objection looking for substantially more housing on the property. And so we're able to work with them to not only avoid an objection, but the other thing that I was able to do is use those two properties in a way that is really advantageous to the township. And admittedly, I tried not to get into too much of the weeds on the affordable housing stuff because it is so complicated. But one of the other requirements, as I mentioned, is our unmet need. And so we are obligated to create unmet need mechanisms. We are obligated to provide a portion of it as part of a realistic zoning scenario. If we are working well with developers, for example, ETS and 3450, it means that I can put those properties in the unmet need category and use them to satisfy that obligation, as opposed to needing to be in more of a defensive mode, as I am with 3641, because those folks may object because I anticipate they're going to be displeased with the density on the site. I want to have the most defensible plan possible. And so where we're working well with developers on existing developed property, as those are, it means that I can rightfully put them in the unmet need category and know that I can say that these sites are generating realistic zoning. I know that I have developers that are comfortable with those densities. If I knew that they were not comfortable with those densities, it means that we might not be able to claim that we fully satisfied our requirements for our unmet need, that we have realistic zoning, because potentially I'm going to have somebody challenging that. But here, where we're working with developers, it gives me the ability to put those sites in that category as opposed to generating RDP. And the real benefit to the township is ultimately less change and less sites need to be rezoned in order to meet our affordable housing obligation. So I hope that's clear. I fear it's not, if I'm honest. But maybe a more simple way to put it is working well with developers means that we can structure our plan in a way that is most advantageous to the township. Maybe that's a very short answer.
But I think that's appropriate to say that because anything further, we'll be talking about litigation.
Right.
Yeah,
So as the transparency was full blown right now, and I don't,
I'm sorry.
which is fine.
Maybe Art needs to sit next to me so he can kick me.
But the township, it's always been our policy, as long as I've been connected to the town, which is like more than 25 years in serving in various capacities, we've always taken our affordable housing obligation as also a moral responsibility to the community and make sure everyone has the ability to own a home in our community. So, we always will have a defense with regard to that. We will never be one of those towns, and there are towns that say, not in our town, we're not that. And the other thing I want to just tell you all, we're running up against a 5:30
Oh, right.
deadline, so.
There's a reason why.
So, and I know that you've got an obligation that you have to go to as well, so if there's any other questions.
Mayor, if I could ask one question, I hope it's a simple one for Mr. Bass. Is the submission of new property into this plan an ongoing process, or is it just once every round? Or is the round sort of?
No, I'm sorry to say, it is ongoing. I have another town that just to put it in context, we adopted our housing plan on Monday, and today we got a letter from a developer, and next week we have a meeting with them. And that is the unfortunate part of taking a vacant land adjustment. We can't meet our constitutional obligation, and so the burden to work with developers and to create opportunities where they become available is very high.
No, I understand. Thank you for that, because I feel for council's benefit. The reason why I ask the question is because I feel like with how the housing crunch in New Jersey and everywhere, I feel like this will be an ongoing issue, so thank you.
Oh, I think we'll get more letters.
Yeah. So if there's no other questions, could we have a motion for the resolution, a second, and a vote? Unless someone has.
Thank you very much for that presentation.
Thank you.
I'll make a motion. I'll move A1, number 241, authorizing resolution of council endorsing the housing element and fair share plan adopted by the Lawrence Township Planning Board.
For a second?
Second.
Madam Clerk, if you could call the roll, please.
Mr. Bobbitt,
Yes.
Mr. Kanaki,
Yes.
Ms. Berry,
Yes.
Mayor Farmer.
Yes.
Thank you, Val.
My pleasure. Thank you.
Thank you, Beth.
And then we just have one more resolution.
Mayor, if it's all right, I'll move A2, number 242, authorizing the renewal of 2025-2026 ABC Hotel/Motel license for JSK Princeton LLC.
That's just a regular, it's a normal, we doing our ABC license now. They were just one that, didn't get on our last round and on our June meeting. This is Red Roof Inn. It's a hotel motel.
I thought we just did that.
They were one, this is one that didn't get on the last one. This was the final one. We have 28 of them. And this is the 28th one.
Second, we need a second.
We have a second?
Second.
Okay, Madam Clerk, if you call the roll, please.
Mr. Bobbitt.
Yes.
Mr. Kanaki.
Yes.
Ms. Berry.
Yes.
Mayor Farmer.
Yes. I just have a question. There's no public participation for that previous presentation on the housing.
No, I think just public participation in general.
Okay.
Yes.
I know we have someone in the audience.
So you want to open that up for public
Yeah,
participation? and
the
then-
public.
Do you want to?
Yeah, open it up.
You have to.
Yeah.
Okay, open for public participation. Seeing none. Thank you. Nice step.
Bueller.
Now,
And now,
Motion to adjourn.
motion to adjourn. All in favor?
Aye.
Thank you once again for coming in. We have our obligation.
My question is, when does this,
Nicole, are you on?
it's off?